This meeting of the Senate Public Safety Committee to order. I'd like to ask our very own Senator Vice Chairman Harper to open us in a word of prayer.
Thank you, Mr. Chairman. Let's pray. Father God, thank you for this day and thank you for all that you've done for us. We pray that you give us guidance and wisdom as we do about the people's business here under this gold dome. We pray that you allow us to make the best decisions in all the work that we do here. Pray that you give us safety as we depart our own ways this evening as we leave this place. In your name we pray. Amen.
Amen. Thank you. As this is going to be our final meeting before sine die for the full Public Safety Committee, there could be some others. I do want to take a moment to recognize a few folks. First, I want to recognize Allison, our doorkeeper team, who does a great job. Great job. Alex with Senate Research, who always brings us all of our bill summaries. We've got Jenna with Legislative Counsel. We've got Sasha with Senate Press. We got Gabe, who's been our intern, and most importantly, Allie, who does all the real work around here. Let's give them a round of applause. It's a great team of people. We appreciate all of the work you do. We could not do this without each and every one of you, so thank you. Okay, we've got 7 bills in the calendar today. We're going to go a little bit out of order because I'm going to ask up my friend Chairman Alan Powell if he wouldn't mind coming first. I know he's busy with his committee and other stuff as well. Either way, whatever you prefer, Representative Powell, and we're going to hear first House Bill 466, and I do want to let everybody know that Chairman Robertson over there does have a slight amendment that was worked out with, I believe, the bill's author and a couple interested parties, so I'll turn it over to you, and let's make sure we're on the same LC number if we could, Mr. Chairman. We're flipping. Hang on a second. We're just going. All right, 466 in your folders. You should all have LC 393058S. Is that what you have, Chairman Powell?
Thank you so much, Mr. Chairman. This is the driving improvement school upgrade and DUI school upgrade, Section 1. Because of certain things that's changed with the nature of the DUI courses, the provider PRI that writes these risk reduction programs has suggested to go from 20 hours to 16 hours. There was a good bit of discussion over in the House about this, but after certain testimony, the DUI school, those people who have to attend those courses, they usually do this on a weekend, and it's 8 hours on one day, 8 hours on the second day of the weekend, and then they have to come back for 4 hours on the Monday. So it's all contiguous. And PRI has been working on this, and they've adapted the program to make it more concise. And that's the best that I can explain that part of the bill. Ms. Doty was kind enough. She did a lot of cleanup because a lot of this was antiquated law. Sections 2 would allow these schools to use a Zoom in these new times. You may remember that last year we ran into a situation where a lot of these kids or young adults couldn't get there because of the virus. They couldn't get there, so this would allow Zoom meetings as directed by the Department of Driver Services. Section 3 is cleanup language. Section 4 was cleanup language. 5 was cleanup language. In Section 6, this allows for third-party testing to provide the road test. There again, you may remember that last year we had somewhat of a quandary because of when the virus first hit, that they actually exempted a lot of the drivers from taking the road test. This would allow third-party testers for these to allow the driving schools to do third-party testings after they meet criteria by the Department of Driver Services. Schools can be licensed if they've been licensed for 2 years and they've met the requirements of DDS. This also allows the third-party testers to administer that road test to all applicants, not just the ones in their schools. Section 7, cleanup language. The Department of Driver Services issues special licensing training to these to the school and to the teachers of these schools. Section 8 is cleanup language for the CDL schools. Has no effect since that's controlled by the federal licensing codes. Section 9 allows Zoom again. Also allows us third-party testers to be authorized by DDS with specialty training by them for 6 months training. And then on Section 11 is that the schools have to notify the Department of Driver Services if they transfer ownership of their schools.
Very good. Thank you for the review of the bill. Before we talk about the amendment, are there questions from the committee members? Seeing none, I'm going to recognize Chairman Robertson to talk about his amendment, and then we'll see if there's any public testimony.
Thank you, Mr. Chairman. Thank you, Chairman Powell. I appreciate this, and I really appreciate the third-party aspect of it, too, especially I noticed that and was extremely concerned when all of a sudden we were giving driver's license to individuals who had not gone through the driver's training, and even that during a pandemic, I think, is a very dangerous precedent. But my amendment, if there is no objection, it would be AM 390315. It would amend the substitute to HB 466 LC 39305-8S by replacing lines 9 and 10 with the following: ownership of driver training schools, comma, risk reduction programs, comma, and driver improvement programs, semicolon, to provide for definitions and conforming changes, semicolon, to provide for related manners, semicolon, to repeal. And then the second part of the amendment would be replacing lines 362 through 371 with the following. It'd be code section 43-13-7.1. Whereas there's a change of ownership of a driver training school, comma, risk reduction program, comma, or driver improvement program, comma, or the department shall be notified no later than 30 days after such change in ownership, period. After any changes in ownership to any person otherwise qualified to operate a driver training school, period. DUI, alcohol, or drug use risk reduction program, comma, or driver improvement program pursuant to this chapter or Title 40, comma, the department shall consider the duration of operation of any previous owner in any required calculation for duration of operation by a successful owner, period. And that's a close quote. The purpose of this is to make sure that these schools, if they are sold, that we're maintaining the integrity of the programs there, and that those who have owned these businesses prior can carry some of that institutional knowledge as proof that they are qualified to run these schools.
Thank you, Senator. I know most of us know Jeff Breedlove and all the great work he does for substance abuse. This was very important for him, and I don't believe he's here today. I know he had some conflicts. So, and Mr. Chairman Powell, I believe you're okay with this amendment. Is that correct? Great. Okay, so we've got that. We'll pass that around. Right now, I don't have anybody signed up to speak in this bill. Is there anybody in the audience who wants to speak on this bill in particular? We're talking about House Bill 466. All right, seeing none and hearing none, I will open it to the will of the committee. All right, let's go for the amendment first, if we could, Senator Robertson.
Yes, sir. I make the motion, and correct me if I'm wrong, Mr. Chair, I'm making the motion that the amendment be added to LC 393058S.
That is correct. Do we have a second? Second from Senator Lee Anderson. Is there any further discussion on the amendment? Hearing none, all those in favor of the amendment, please say aye.
Aye.
All opposed, please say no. Okay, now we have a perfected committee substitute. Do I have a motion? I've got a motion due pass from Senator Cardin Summers. Do I have a second? Second from Senator Anderson. Any further discussion on the perfected committee substitute for passage? I have a question from Senator Jackson.
I don't have the copy of the amendment, so I'm not 100% sure, but do we define those additional, Senator Robertson, do we define the additional types of courses that you named out in your amendment? Are they defined?
I believe those are already in law. All it's doing is talking about the driver's training course that those are part, defining the business which is purchased by the new owner.
Right, but so your first, I mean, in the earlier lines, I think it's line 9.
On the amendment? Or
On your amendment, you add the number. Can I see the amendment? Do we have a copy of it?
Here's one. It's got a number.
Thank you. So I just want to make sure we get this right. So yeah, you on line 9, you add risk reduction programs and driver improvement programs, and you add that later on at the end, those same ones, risk reduction and driver improvement programs. Are they defined though later on in the section, like we've defined driver education training course, driver training school? Do we need, I guess that might be a question for.
They're in Title 40, that's
So
why
we-
there's a reference to the Title 40.
So we don't have to define
Right.
it. That's all I want to know.
Okay, good.
Thank you.
Any other questions, Senator Jackson?
Nope, that's all I want to know.
Okay. Any other questions? I'll call a vote. All those in favor of the perfected committee substitute, please say aye. Aye. Opposed, please say no. All right, passes unanimously, and who will be carrying this for you in the
I
Senate?
think Senator Robinson.
Well, fantastic. That's a good one.
All right.
All right, terrific. Thank you so much. We appreciate your help.
Did you want me to wait for, I have a second bill, do you want me to wait on this one?
Well, let's see here. While you're there, I think we ought to just keep you going there. Why don't we just get HB 200 next?
Very good.
All right, in front of you, you're going to see House Bill 200. And let's make sure we're all running from the same version. Actually, I thought we had hang on a second. I thought we had a committee substitute for this bill. We have a committee substitute for this bill, but I don't think we have it in our folder, so we may need to just wait one moment and make some copies, if we could,
Very
Chairman.
good.
Do you have a copy with you?
I don't, it was, remember I sent an email saying it was ready last week.
Okay. All right, well, we're going to go ahead and just pause on that for a moment, if you wouldn't mind, Chairman, while we get the correct copy. We have a committee substitute. And in the meantime, why don't we go back up to the very beginning of the agenda, and we will hear House Bill 179. Representative Camp, are you here? Oh, there you are. Perfect. Come on down. I think this one should be fairly straightforward,
Which is,
and it has nice pictures. That's right.
it does. I have illustrations. Thank you so much, Mr. Chairman and committee, for hearing this. I've had the privilege to get to meet many of you and look forward to working with you. This is an interesting bill. It's LC 392933S, and it's interesting because it brings, I think, the love that we have for our troops and support our troops license plates, the love we have for our family and friends who've been unfortunately impacted by cancer. And this bill actually provides for a license plate for Support Our Troops, and over the past several years, Support Our Troops has dispersed $3.9 million to families and military installations throughout Georgia. So I think we all love our military families and the sacrifices they make for us. Secondly, we have the breast cancer, which we're going to update the license plate. Over the past 5 years, the sales have declined because it's the same tag. So this is going to update the plate. So it's Fund the Fight, Find a Cure. And we actually have a visual over here if anyone needs it. And then lastly, the third plate, which is a brand new plate, is a fight against all cancers. And the money that's raised from the latter two plates will be dispersed by the Georgia Center for Oncology Research and Education Incorporated, or CORE. So I'm open for any questions.
Fantastic. Thank you for that great summary and overview. Are there questions from the committee members for Representative Camp? Seeing none, what's the will of the committee? I got a motion to pass from Senator C. I've got a second from, I've just totally backed out on Senator Payne's name. Took me a moment. Okay, Senator Payne. Whew, it's been a long week. Any further discussion by the committee members? Hearing none, we'll call a vote. All those in favor, please say aye. Aye. Opposed, please say no. Passed unanimously. And who is going to carry this for you in the Senate?
Senator Sheila McNeil.
Senator Sheila McNeil, that's perfect. All right, we're going to make a note of that.
It is,
Ooh.
and I appreciate her, and thank you all for the opportunity.
Thank you so much. That would be in order.
I don't know who said it. All these folks got masks on, you can't tell.
Well, we know it wasn't a woman's voice.
All right, order. All right. We're gonna wait on Ally to come back here for 200 again, so why don't we jump in, if we could, to House Bill 495, which I think will be a quickie as well. Representative Crowe, I think I saw you there, very good. Why don't you come on down here? It's a great bill for our GBI.
All right. Thank you, Mr. Chairman, members of the committee. This is House Bill 495. This is a GBI department bill, and basically it just codifies a practice that's already in place. So the Sexual Offenders Registration Review Board, or SORB, classifies sex offenders and categorizes them. And they have investigators that used to work for the GBI, and over the years those have through attrition have been reduced, and now this is moving one position from the GBI back to SORB to handle those investigations, keeping one investigator's position at the GBI to handle criminal history information gathering and reporting for SORB, which they can't do on their own. This was actually part of House Bill 720 last year. It unfortunately didn't pass because of the shortened session, but these monies were allocated. The position was funded to SORB in the FY21 budget. So this is basically just clearing up and codifying the relationship of those positions now.
Very straightforward bill, and we are operating off of LC 412900, is that correct?
Yes, sir, that's correct.
All right. Questions from the committee members? Seeing none, I've got a motion to pass from Senator C. I've got a second from Senator Jackson. Is there any further discussion on the bill? Seeing none, all those in favor, please say aye. All opposed, please say no. Passes unanimously. And who will be carrying this bill for you in the Senate?
Senator Robertson.
Senator Robertson. All right. We got it. Thank you so much.
Thank
We
you.
appreciate it. All right. We're going to pass that substitute for House Bill 200. We're just going to hang on one moment, folks. Okay. Chairman Powell, if you'd like to come back up.
If I might, could get a copy of the substitute. Thank you.
Okay, ladies and gentlemen, you've got in front of you House Bill 200, and as a committee substitute, so you should be looking at LC 393041S. And I will recognize Chairman Powell, if you would. Let's talk through the bill.
Thank you, Mr. Chairman. I'll address the base of the core of the bill. You know, we've got several companies today, and they're manufacturing three-wheel vehicles. And these things come in such close resemblance to a three-wheel motorcycle, there need to be a definition, because with a three-wheel motorcycle, they have to wear the same protective gear, helmet, and stuff like that. But in the case of the three-wheel cars, they shouldn't. And we've changed the definition a couple of times to try to hem this up. But what we're doing, we're moving away from the steering wheel and directional controls to seat belts and a frame to partially or fully enclose the operator as a definition for these vehicles. And that would be the definition of a three-wheel car as opposed to the three-wheel motorcycle.
Excellent. And then we've got addition, something we've actually passed a couple of times, Senator Robertson, and I know he and I both had worked on this, as well as other senators, which you will note on Section 3 that simply modifies a code that any civil action really relating to evidence of failure to wear a seatbelt can actually be asked, as opposed to not being able to ask someone if they wore their seatbelt or not. So, pretty straightforward. Well, some could say it was improved and perfected. All right, I see I've got a question from Senator C.
Thank you, Mr. Chairman.
Would you grab the microphone? Thank you.
Mr. Chairman, author of the bill, did you not bring us a nice colorful picture of what this three-wheel? No?
I'm sorry, because of the virus, they just don't transport these things as freely as they used to.
Oh, well, a picture, something, I'm visual. Okay.
I'm sorry, Senator.
Senator, you've actually seen these probably before and didn't realize it. Sometimes they look like they're old motor cars or something like that, whereas a couple of seats and it's you wouldn't even notice a motorcycle. But just it's got a front wheel or a back wheel and two, and vice versa. There's two on the other side. They're really kind of a cool little thing. You'll see the Morgans and other really neat little things that have been out there for some time. It's basically a cool looking convertible, is what it is.
A cool looking convertible.
It is. I think you'd look great in it.
I look great in it.
Second. All right, Senator Jackson, go ahead.
Yes, thank you for bringing this bill forward. When we say a frame to partially or fully enclose the operator, does that mean that it just has to be the steel bars and stuff? Like there doesn't have to be any type of actual cover over the driver?
It might have a cover, it may not. Most of these have a steering wheel, they have the directional controls, but they also, the easier definition, they're trying to make this uniform nationwide. So there's a definition instead of having 50 different code sections, so that if a vehicle, if somebody's driving one of these three-wheel cars in the state of Georgia coming from out of state, if they come from out of state where they don't have to wear a helmet like it's a motorcycle coming into Georgia, you would define this to Georgia. We're trying to get the uniformity across the country on these vehicles.
May I ask a follow-up? Do these vehicles have windshields?
Yes, ma'am, some of them do and some of them don't.
Some.
A variety of these, there's multiple companies that make these vehicles, and they're basically considered a vehicle, a car instead of a motorcycle.
Okay.
Generally, anything that seats more than one person is considered a car.
Who's speaking to the amendment, or to the section 3?
Okay. Other questions? I give another question? All right. I think we had Senator Jackson's microphone still on, so are you done? Do you want to wave?
I'll wait for the
Okay, all right,
bill.
continue on.
I thought I heard you say anything that seats more than one. Is that what you said?
A lot of these vehicles, they seat two people.
But did I understand the more than one part? I'm just trying to differentiate. What I was seeing, it looks like it. Anyway, that's okay.
Okay.
Jesus.
All right, I'm going to bring it back to Senator Kim Jackson.
Sure. Mr. Chair, are you the one who can speak to section 3?
I
Or-
believe both Senator Robertson and I can speak to that, and I think we have somebody else who I can pull on the phone too, if we need to do that. But why don't you go ahead and ask a question? We'll figure out who the most appropriate person is.
I would just like some more information on it. I don't really have a specific question, but would like to have somebody speak a little more plainly to it.
Certainly, and then I think is Nathan in the room? I'm not sure I see him. I know we are overflowing into the outside world here. Tell you what, we'll conference a couple of folks in here if you hang on one second.
Thank you.
I don't have the number here. Mike, are you here by chance? Mike Borman? I am. Oh, well, then I don't have to call you, do I? Why don't you come on down? You can go right to the podium there.
This is about your section C.
Good afternoon.
All right.
Good afternoon. And Senator Jackson, I think you wanted some more information about this.
Yes, sir.
Very brief background on me. Been a Georgia lawyer for over 20 years. I do civil litigation, primarily defense. And so I've dealt with the admission or non-admission of seatbelt evidence for decades. And we think it's very important that this gag rule that we currently have get changed. There's no reason to hide this critical evidence from the jury, and I've got 3 simple points. The first is the jury needs seatbelt non-usage evidence to do their job. As I'm sure you know, and everybody knows, that we have apportionment of fault in this state, and apportionment of fault requires the jury to look at all the evidence and determine who is at fault for the injuries. So there is little question now, after decades of research, that if someone chooses not to wear their seatbelt, the non-usage of a seatbelt can cause or contribute and greatly worsen injuries. The second reason is defendants needed to tell the whole truth about what happened in a crash. We tried a case a few years ago representing an auto company, and a minivan was driving down the road. A reckless driver impacted the side of the minivan and ripped the sliding glass, or ripped the sliding door off. The plaintiff tragically was ejected 50 feet in the air and injured. We tried the case and could never tell the jury that he was ejected because he chose not to wear his belt. So we go through 2 weeks of trial, and the jury was wondering if there was something wrong with our seatbelt system, which there wasn't. And then as soon as the case came over, the jurors came up to both sides, the plaintiff and defendant, and said, why is nobody talking about the seatbelt? That seems to be a critical part of what happened in this crash. And we had to tell them there's a statute that really doesn't make sense in Georgia, but it's been on the books since the 80s. The third reason is because this is in no way unfair to plaintiffs who are bringing suits. You can't claim unfairness when the jury's job in these cases, and especially automotive product liability cases, is to determine what caused the injuries in the case. And that's all this would allow us to do. Plaintiffs certainly can oppose it, and there can be different evidence on it, but to not allow defendants to introduce this evidence, frankly, makes no sense. I would be more than happy to answer any questions that anyone has.
Go ahead.
Sure. Are there other states that have this gag law as well?
There
Do you know
are.
how many?
I don't know the current exact number, but it's a little more. It's about half, I think. And in the history of this is, in the 80s, a lot of these gag rules were passed, and the reason is because back in the 80s there was a seatbelt usage rate that was under 50% in a lot of states, and including Georgia. At that time, there were some people that thought that if you chose not to wear your seatbelt in certain crashes, that may actually help you, because there was a belief that certain people have that you could be thrown clear of the vehicle. I will tell you that decades worth of research by NHTSA, as well as the auto manufacturers, have proven that to be completely incorrect. It is always better to wear your seatbelt. So these statutes were passed decades ago, and now the trend is to certainly get that corrected. And I think, the states are on the road, on the right path to get that done. Just hasn't been done in every state yet. But I do believe, if you check, it definitely is the trend to get these fixed.
And then another follow-up, would this apply, so my understanding in Georgia is that you're only required to wear a license if you're in the front seats, that wearing a seatbelt is not required for backseat passengers unless they're underage. So would this information apply to those passengers who are in the back part of the vehicle?
I believe that it would, yes.
Go ahead, Senator Robertson.
Yeah, if the individual is required to wear a seatbelt, it would apply to them. If the individual is not required to wear a seatbelt, then this evidence would be almost apparent in the courtroom because there is no requirement. So basically what this does, if an individual who should be wearing a seatbelt receives a disproportionate amount of injury, then what passing this would do would be allow the attorneys to ask that individual if they were, in fact, wearing the seatbelt. Because right now, they are prevented from even asking the individual in the courtroom if they had the seatbelt on, because you look at the damage on the vehicle and the damage is minor, but the medical costs are extremely high. And a lot of times that's because of, it's not necessarily the rear end collision that caused 100% of the damage, injuries. Sometimes it's only 30%, and the other 70% of injuries were caused by the individual who should have been wearing a seatbelt, not wearing a seatbelt. So they were thrown into the steering wheel, into the windshield, possibly out of the vehicle. So what he's asking for is just the opportunity to be able to say, were you wearing your seatbelt, to the individual making the claim for the medical costs or others. So those individuals in the back seat required to wear the seatbelt would have to confirm whether they were or not wearing the seatbelt.
All right, I've got a question from Senator Anderson.
I don't know who this question could go to. I might be the author of the bill. But basically, these vehicles are two-seaters, right?
Yes, sir.
What, how about the law that we have for children, the way they have to be in the back seat? Is it automatically, if they in the other seat, that they would have to abide by the law for children up to a certain age?
Under a certain age, children have to be secured.
Okay.
That'd be a car seat. Okay. Do you have another question, Senator Jackson?
Just follow up to your, Senator Robertson, just to follow up to you. So from my understanding from what you said is that basically those who by law are required to wear a seatbelt would now, using this law, be able to be asked if they were wearing one. But is there anything in this provision that actually protects the information about seatbelt compliance for those who aren't by law required to wear one? So I would say, so I'm trying to be clear that those who, by law, I as an adult, if I'm sitting in the back seat, am not required to wear a seatbelt. So I want to know, is there anything in this provision that protects that information as it has in the past from when it comes to disclosing information in a trial?
What this does is if I'm vehicle number one and you're stopped at a traffic light and the driver who is obligated to wear a seatbelt is there and you are sitting in the back seat and you're not wearing a seatbelt, I hit the rear end of your vehicle. You each receive physical trauma. So when y'all end up filing a lawsuit against me, and when it gets to court, this question would be only applicable to the driver of the vehicle who is required to wear a seatbelt. You would not necessarily be required to wear a seatbelt, so your medical damages would not be based on the same piece of evidence as theirs, because of the fact that in the back seat you have a choice whether to or not, and so there's no obligation for you to have to justify, other than the fact on what the estimated costs of your health care or of your physical injuries are. So this is only applicable to those individuals who are required in Georgia to wear a seatbelt, and a lot of that information is ascertained from downloading the digital information from the vehicle. It can tell who was sitting in what seat, who had seatbelts on, all this other kind of stuff. But the problem with that, to some degree, is the fact that now Georgia, the owner of the vehicle has to, in many cases, offer that information up or the ability to download that digital information. But in this right here, in deposition or in court, and I know the attorney will correct me if I'm wrong, then they will be able to ask, if you say, hey, all these injuries were caused because Randy hit me, and they say, okay, were you wearing a seatbelt? And if you say no, and you were required to wear a seatbelt, then at that point, it becomes the court's job to determine how much of the injuries were caused by me striking and what additional injuries were caused by you failing to follow Georgia law by wearing your seatbelt. And I know I talked around the world to get to
No,
that. so.
I understand what you're saying. I just don't know that it says that in the bill. That's,
If we're talking about evidence, I don't know how you protect evidence from something, because you're not charged with a crime. Therefore, you cannot. Nobody's going to Mirandize you and question you. Any information you give at the scene, or any information ascertained at the scene, a lot of times is unrequested utterances from individuals involved in the accident. And if the officer asks, "Were you wearing a seatbelt?" Which is a rare question, because normally law enforcement investigating scene do not ask that. People in your profession do. I mean, because y'all have to try to figure out internal injuries and things of that. So really, that doesn't apply to, I think in court, more weight is given to the individual who was violating the statute than an individual who was innocently sitting in the back seat and not wearing a seatbelt because they were not required. And I think in most cases, the at-fault driver would be 100% responsible for hurting that individual.
Okay, and just let me finish off on your question. It says on line 54, violation of this code section. You couldn't have violated it if you didn't have to wear it to begin with.
that's what I needed.
Okay.
Thank you.
All right, thank you. We're going to have here one more person on this. I've got Jason Rooks here with GTLA. Jason, come on up to the podium here and just introduce yourself to us, please.
Thank you, Mr. Chairman. I'm Jason Rooks with the Georgia Trial Lawyers Association. I appreciate these committees being broadcast through the internet, so I got notice of, I guess, a substitute to Chairman Powell's bill. This issue of seatbelt admissibility has been heard each year the last 3 years in various committees, this committee as well. We had a full committee, probably 45 minutes on this issue in Judiciary a couple weeks ago, so I won't rehash those legal arguments, but I would like to mention 3 things. Number one, as to the data that is supposedly easily and cheaply downloaded, that's not the case. Most of the data is proprietary per manufacturer, so of course Ford can get their data cheaply, but if in the civil cases, if you're the person being the victim of the accident, you need to go to a third party, and there's been testimony that it ranges $1,000 to $2,000 depending on the situation. But more importantly, as to that data, black box data came in about 12 years ago. Right now in Georgia, only 50% of the vehicles have those black boxes. So the idea that we can all get this information easily is not accurate. And most 50% of wrecks, you won't have the information at all. The issue that goes on with the admissibility of seatbelt evidence, it's part of a balancing test the courts have done for decades as to the probative value versus prejudicial value. And what I'll let you know is if someone runs a stoplight and is drunk and hits you and you're not wearing your seatbelt, you're not allowed, because of the prejudicial value, to put into evidence the citation or the DUI citation. So what happens is there's probably 4 or 5 things that both sides would like to get in, and they can't because the courts have ruled it's too prejudicial versus the probative value of the issue at hand. And so, again, this is, I don't want to go through the cobwebs in my law school of the probative versus prejudicial.
Please don't. You'll
Yes,
lose us.
thank you. And so the third point I'd like to make, everyone supports wearing more seatbelts. In this state, we have a $15 fine. If you want to encourage more seatbelt wearing, you raise it more than $15. You don't take the 98% of the people who wear a seatbelt, and they are the victim of someone else's negligence running into you, and then put them on the defensive to have to show they were or were not wearing a seatbelt in a vehicle that may or may not have the black box data. This is about driving up the cost of car wreck cases, because that's exactly what it's going to do to the victims of those car wreck cases. And I know there's other issues in this committee, so I'll stop there.
Thank you, Mr. Rooks. We appreciate that. I got a question from Senator Robertson.
Yes, sir.
You and I found out about this amendment probably about the same time. Okay? So, no, I just want to clarify that with you. And so I think me talking about the black box, the word affordable never came out of my mouth. I'm very familiar with the instrument it requires.
Yes,
I'm
sir.
very familiar with the many cables that are required. I have an auto dealer manufacturer in my district that does not provide a cable for this kind of stuff to be downloaded. So I understand it completely. And as far as the DUI and the citation related to the accident, that's an attorney back and forth. Sometimes I've seen that information go into the courtroom where the individual where the individual's impairment was brought up in civil cases. And so I have no doubt in your law school ability that you know of case law where it was prevented from being brought into the courtroom. And I respect that wholeheartedly. As far as the intent and, you just seem upset about this coming up again. I think I personally debated this 3 years ago.
Yes, sir.
Over on the Senate side. And nobody in this committee, nobody in public safety ever holds the victim responsible for the actions of a bad actor, whether that is somebody who runs a red light or whether that is somebody who commits a felony under Georgia Title 16. So the purpose of these are to discuss it, to find out the good and the bad in all of this. But when it came to the black box testimony, it was just the equipment's available. I've actually 3 years ago, to the detriment of my family, did way too much research on this, got way deep down involved in it, so I understand the equipment very well, and you can find it anywhere from a $600 download up to, I've seen them as high, over $2,000 download. And the information contained in the black box belongs to whoever owns that vehicle. So the party that caused the accident can't just run up there and start downloading. Neither can their attorneys or other things without, and as you are well aware, without going through the judicial system. And rarely would they probably get permission. Because self-incrimination is extremely important in the law. But I saw this when you saw it, and so I know sometimes, I think 98% of the time you and I are pretty solid as how we agree on things. So please don't interpret what I say beyond anything other than what my Harris County accent says.
Yes, sir.
Because I wasn't
repeating-
saying it was cheap, inexpensive, any of that. I was just saying it's available.
I was simply repeating the testimony from the Judiciary Committee that you were not, and I wasn't referring to what you said, but the proponents of this several times have made these claims.
Yeah, and you and I track on that, but this committee in here, we're a whole lot more common sense than my good friend Chairman Strickland and some of those other folks get. We don't get into near as much Latin, and we don't get anywhere deep in the weeds. But I appreciate you.
Yes, sir.
All right, we're going to do just another question or two, and if we don't keep moving, we're going to kill some really good bills this session. So, Senator Jackson, one more question.
Yeah, so I just want to be clear. If I were, I'm going to make sure I understand your point here. If I were involved in a car accident where I was the victim, are you saying that if we allow seatbelt information to be admissible, then my attorney would have to be able to prove that I was in fact wearing a seatbelt in order to make sure that I received all of the benefits that I was entitled to? Is that what you're saying? That then suddenly that the onus would be on me as the victim to have to prove that I did the right thing,
Certainly.
even if I didn't cause the accident?
Very good question.
Is that what you're saying?
In the situation where the defendant, the person ran into you, if that person or their insurance company alleged that you were not, and when we went through this 3 years ago, I looked up Florida law, which has a seatbelt admissibility and a narrow exception, and I called lawyers down there, and they said in every car wreck case, as a matter of course, it is alleged that the victim was not wearing their seatbelt. Now, how quickly it subsequently gets dealt with is a separate issue, but the information that from talking to lawyers in Florida is it's a common practice for the insurance companies to make that allegation in their response to your lawsuit.
Thank you, Mr. Rooks.
Thank you.
Appreciate your testimony. I'm not sure your last part that you mentioned is consistent with what we've heard from others, but I do appreciate your testimony today. Okay, we've got a committee substitute for House Bill 200. What is the will of the committee? I got a motion to pass from Vice Chairman Harper. Do I have a second for House Bill 200? Second from Senator Robertson. Any further discussion on House Bill 200? Seeing none, all those in favor, raise your hand, please. 1, 2, 3, 4, 5. All those opposed? 5 to 2. Motion carries. And who is carrying this for you in the Senate?
Well, with this language, I'm not sure who's going to.
All right, we'll handle that for you.
Let me get back to you on that one. Senator Mullison was going to handle this. So
He'd be a good one.
I know he would.
Thank you.
If you would, feel free to put his name down.
Thank you. All right, next up, we're going to hear House Bill 247, Representative Carson. Okay, in front of everybody here, you have committee sub, you have LC 393062 ERS. And why don't you go ahead and present, and then there'll be a couple other folks presenting, I believe, on some of the other parts of the bill as well.
Right. So, thank you, Mr. Chairman, members of the committee. Can I just verify the LC number, Mr. Chairman? 3062 ERS, is that right?
That is correct.
Okay. So this, most of you were probably here, except I don't know that Senator Robertson was here when we did the hands-free law back in 2018 and a study committee before that. Very happy to announce, just like what was in the press release back in January, that distracted driving crashes are down, fatalities are down. If you look year over year, they're down from 2016 to 19. They're down 4.5%. If you include population and traffic growth, traffic crashes are down 12% in the state. So that's a good sign. I think there was I sent some other information in regard to endorsement letters in regard to House Bill 247, but I have a graph that was. I'm sorry, Mr. Chairman, I did not get this to your aid, but this is a graph in regard to. You can see the trajectory downward. And I'm going to pass this around if I may, if that's all right. This is a graph of distracted driving crashes as from data from GDOT that was provided to me by the by some agency, state agency folks. And you can see a progression down of suspected distracted driving crashes as well as confirmed distracted driving crashes. I'm going to pass that around. Senator, say. Thank you. What the Senate bill, so that's the background of this. On House Bill 247, what we're looking to do, it's really just two items, Mr. Chairman. You can see on lines 120 through 124. This removes a provision where someone can, upon their first time offense on a violation of the hands-free law, they can essentially sign a one-page affidavit saying, this is my first time being charged with this. I have a Bluetooth device, I have a bracket, I have a receipt for one, and the individual shall be found not guilty whatsoever. The problem with that is if I do that in Cobb County, Mr. Chairman, and not that I would ever drive with the phone in my hand. I think that would make front page, wouldn't it? I think it would. But if I were pulled over in Cobb County and I went to Cobb County Magistrate Court and filled out that affidavit and signed it and so forth, and then I would dare do that in the Senator's 56th Senate District in Fulton County, there's no way for the Magistrate Court for the city of Roswell or Fulton County to track that against Cobb County or city of Marietta and so forth. When we passed the hands-free law, it went into effect in 2018, July 1st of 2018. It had 98% awareness among Georgia drivers. And as a matter of fact, it had 99% awareness over AAA membership. And that was 3 years ago, and it's just that much more known. We see all the jumbotrons over the interstates now. This, as I understand it, this was language, the waiver was included as more or less a compromise to get drivers aware of the new law and it's coming. This was adopted from another state that had it at one time. That state up in the Northeast has since repealed its waiver. And I'm just asking Georgia to do that as well. I think there's going to be some more speakers in regard to this. The only other changes from my version of House Bill 247 was to make it a flat, simple, but no increase in the fees, 50, 100, 150. Those are really the only two changes, the waivers and the flat fees.
Thank you. And let me take a moment to thank you for your leadership. The work you have done in this have saved people's lives.
Thank you for that.
And we know that we still need to do more education and work on this, but the more that people are cognizant, and as I always like to talk about, I just chat with my girlfriend Siri. You can do an awful lot of stuff. I do want to recognize Vice Chairman Harper, though, in language that he added in lines 36 and 37, which I think is pretty simple and straightforward.
Mr. Chairman, thank you, Mr. Chairman. In lines 136 and 137, you'll see a new paragraph 5, which is an exception to the underlying law. I think I like Chairman Albers. I know this has come a long ways in what we've been trying to do, but under current law, you cannot touch your phone unless you pull off the side of the road, unless you fall under one of the other exceptions other than a single press. We kind of had some discussion about this when the initial bill was here a couple of years ago. We never really moved forward with it. I think this is an appropriate time maybe to move forward with it. So basically, if you're at a full and complete stop, you would have the ability to touch your phone. If you need to change the address of where you're going, the directions of where you're going, or I think it's just a common sense approach. If the vehicle is at a complete stop and you're in compliance with the rules of the road, that you would be able to do that, and that's simply what that paragraph 5 would do, Mr. Chairman.
Thank you, Senator. Appreciate that. We've got a question from Senator Payne. Okay, we've got a little more speaking to do here. I'd like to, this time, I'd like to recognize Senator Robertson.
I just want to tell the bill's author this is timely and this is perfect. I think we've tested enough. I know in my local community, I think the first day they ended up writing something like 600 citations, and the second day it was closer to 800. And one of the problems was a problem that Senator Vice Chairman Harper is correcting, is that individuals were being ticketed. But I carried my niece when she got a citation. I carried her to the court. She had the device that she purchased. She was stopped leaving her college campus and driving with her phone in her hand. And so they, dismissed that first case. And the question in my mind is what prevents her from coming back every time with that device in her hand? And I think Senator Albers is exactly right. By fleshing this out the way you have, like was said before about increasing fines on seatbelts or hands-free and everything, you're saving lives. And I greatly appreciate this. And luckily, I changed mine from gangster rap to the Ben Shapiro show by talking to my truck. But for those who can do that, they can do it now, thanks to Senator Harper stopped. And thank you very much for doing this.
I appreciate that.
It was my understanding you're down to just liking two types of music, Senator, both country and Western. Is that not true?
That is a strong negative comment. I don't.
If I could, Mr. Chairman. I appreciate Chairman Harper bringing this and for the chairman making me aware of it. I do have a concern, whereas first of all, in regard to compliance with the law, it's not illegal to touch your phone. There are some states, such as say California or Oregon, that have a one-touch permit, and I'm only allowed, so on my Google iPhone, I'm only allowed to touch it once or what have you. We don't have that. We simply have a hands-free. Now, you're not allowed to text, scroll on the internet, and so forth, but you are allowed to touch your phone, either the case or on the screen or what have you. I do, in public safety folks that do have concerns about the proposed language in 136 and 137, whereas if I'm, for example, if this were to go into effect, then I could simply hold my phone at a traffic light or what have you. And if I'm doing that, I'm not seeing pedestrians. I'm not being cognizant of emergency vehicles. I'm not I'm not aware, and I could be impeding traffic. I was given data from the Georgia, from Commissioner McMurray, whereas in various areas of the state, we've seen a 6-second improvement in traffic flow through an intersection. So if a traffic light at let's take Roswell Road and Highway 92, so right up there, and a green arrow lasts for 40 seconds. We've seen additional 8, 9, 10% improvement in traffic flow because people aren't distracted by their phones and they're paying attention. Oh, the next car is moving up, I can go right now. And that's one of the things that happen. I understand where the gentleman's coming from, I really do. But for statewide, if I'm looking at my phone, even at a traffic light, and I'm stopped, I'm not paying attention to pedestrians, I'm not paying attention to the traffic that might be going, and I'm not paying attention to emergency vehicles. I'm causing a lot of confusion for enforcement and the subjectivity thereon, and I would urge caution, but I would leave it up to the committee.
Thank you. We've got a question from Senator Kim Jackson.
Yes, thank you, Representative, for doing this important work of helping save lives. I'm just curious, the form that you passed around indicates that what we're currently doing is working, that it's working quite well. And so why are we moving to a more punitive system when what's happening now is already proven to be effective?
Well, what I would say is when we did the Distracted Driving Study Committee, we saw that when other states put in a distracted drive or a hands-free statute, they were able to reduce traffic fatalities by about 16% to about 17% within the first 2 years, and maybe a point or two more over time. We've only seen a 12% decrease. So what I'm saying is, yes, we're on the right trajectory, but we can do better. And we can see that based on the data in other states. 2 years after they put in a hands-free law, as well as life to date. For example, if it's been in place, say, 4 years in New Hampshire, or really about 18 years in the state of New York, they've seen a pronounced trajectory without these exceptions of texting at a light, without a waiver, without other things like that.
And may I ask a follow-up?
Sure.
So if we were to move forward with the Senator Harper, our dear friend, would you still be in favor of the bill if we were to move forward with the adding of you can use your phone at a stoplight? I would have hesitations based on the feedback that I've heard from law enforcement, and I do want to say this one thing, and I know that the hour's late, Mr. Chairman, but I've been accused, as you can imagine, greatly over the past 3 years about trying to milk money out of Georgia taxpayers' pockets so we can pay for fines. All these fines stay in municipal courts and county courts. I want to save lives. I would guarantee you, I don't know for sure, but I can guarantee you some of the high-profile crashes that have happened, including, I know for sure, on I-16, Harrison Deal, others. If you hear the stories of what happened on a clear day, no other reason for distraction, I would almost bet that had to be to do with phones every single time. Yeah. I'm not after the money. I know a lot of people in this building say that. But I'm tired of the stories that these law enforcement folks are telling me, then they have to, where they're tired of knocking on someone's door at 2:30 to tell them their daughter's not coming home. Why? Because she was texting. I heard one story of a crash, and this before this bill was voted, about 90 minutes before this was voted on the House floor 3 years ago, about a crash of an individual, I can't say who, because I'm kind of sworn to secrecy, because she was holding her phone, and she was not paying attention. They found her body 3 days later in the car, and the car had crushed around her, such that her phone was still like this, with her arm still right here. And the shell, it wasn't a roll cage, but it was a sheet metal crushing around the body of this young 17-year-old girl. And that's why I brought the bill. That's why I just want to save lives. And anything that does not save lives and it would risk lives or
keeping traffic going on various roads, that's what I would have a concern about.
Sure. So I absolutely 100% support you in bringing this here. I just am trying to figure out, do you still like the bill if I go with the senator from the 7th, or do we need to do something different? I absolutely 100% support saving lives and having people not
I've
have
not
their hands.
spoken to Chairman Harper. I do want to ride in his plane at one of these days, but but I don't have a texting rule. I think I know. Well, my family's from Middle Georgia, and I know I have some family in South Georgia as well, down in Tifton Way. I don't know if that's your area, Chairman Harper. I think I know what Chairman Harper is after. I think he's simply representing his constituents, but I can almost assure you, and I think we have some speakers lined up to talk about this. I think can assure you, Senator Jackson, in all fairness to the Chairman Harper, that lives will be at risk. If not, lives will be lost. And I know that this is just a simple text. Let me just send somebody. But when you do it statewide, over 11 million people and 6 million drivers, this provision is not going to save lives. I don't believe, with all due respect to the chairman.
Okay, we're going to do a quick question from Senator Summers, and we're going to take some testimony. If we do not speed this up, some good folks are not going to get their bills, and I think
understand.
Representative
Yes, sir.
Oliver and Holcomb will be pretty upset if that happens. So let's go ahead and go to Senator Summers.
Thank you for bringing this, and I'm like Senator Jackson there. I like the bill, but I kind of feel Senator Harper's language is important. I am in Tifton. That is my district. That's
okay.
You know what I'm saying? And I do feel that, we have some extenuating circumstances that don't fit Metro Atlanta area. And I just, that language is kind of important. And I don't want you to feel like your bill gets cut in half if you don't get that language in there. It may be something we need to readdress. That's what I was simply throwing out there.
I understand. And I fully understand, Senator.
Right.
And I would rely on law enforcement and their
Right.
very quick and timely testimony as per the chairman and his guidance. I appreciate
you, Mr. Chairman. Thank you.
Thank you. Graham Thompson, would you come up to the podium, please, and talk about Section 1 for us?
I believe I may have the Senate rule right, 1-4-1. Due to that rule, I'm going to exclude myself from voting on this legislation. I'm going to excuse myself.
You are excused. Thank you,
sir.
Thank you, Mr. Chairman. Graham Thompson on behalf of the Coalition for App Fairness. As we are talking about cell phones use at the moment, if you'll look at lines 17 through 40 of the proposed committee sub, the proposed language would offer choice and competition in current closed markets. So today, Georgia consumers on your cell phone can certainly select a wireless provider, but 99% of the U.S. phone market is dominated by two companies, Apple and Google. The only thing that makes your smartphone smart are the apps that you use. You use apps to read the news. You use apps to check NCAA basketball scores. You use apps to keep up with your friends and family on Facebook and Instagram. And so what we'd like to do is introduce some choice, because $1, the only way you access the apps is through the app stores, Apple App Store, Google Play, and those are closed systems. So when you go and purchase an app, you see you paid $1 for an app. There's actually a 30% upcharge, a payment processing fee charged by Apple and Google on every dollar that you pay for within the App Store. It's a big business. Just for Apple last year in 2020, $72 billion gross just off App Store revenue. So it's a huge business. The challenge is a 30% payment processing fee for folks in finance or somebody that makes payments online is a really high fee. 2 or 3% is more what the market is today. And so if we introduce choice and competition, we think Georgia consumers will win with more payment options as they pay for apps and services through the app stores. We did a study. So we believe there's 6.5 million Georgians with a smartphone. By introducing choice and competition, we think that 30% fee comes down by an average of 22%. So each of those Georgia consumers will save right around $17. So just over $100 million in potential annual savings for Georgia consumers if we introduce choice and competition in closed markets. So to the language, just quickly, Mr. Chairman, on line 17, a couple of definitions. First definition is a developer. So this is the creator of the app or the service offered through the App Store. Digital application distribution platform is the App Store, the marketplace. General purpose hardware would be like a smartphone or a tablet. And then definition number 4 on line 25 is the in-app payment system, the way that you actually procure the app or service through the App Store. So what this proposed language would do, starting on line 28, it would only apply to app stores that have gross receipts with Georgia consumers of more than $100 million a year. So I think many of the legislators will remember the Marketplace Facilitator Bill, where we required companies like Amazon and other online marketplaces to do certain things, to collect taxes, to give reports to the Department of Revenue. That standard is only $100,000 a year in gross revenue. So we're increasing that by 1,000 times just to show the breadth of the economic activity and the economic nexus these two very large companies have. We estimate almost $900 million a year in annual sales to Georgia consumers through the App Store. So it only applies to the largest app stores with economic nexus. Line 31, basically this is in the Fair Business Practices Act. So for those particular companies with economic nexus, we say 3 things. The first one is you can't intentionally misrepresent, and that's important. Installing a service is good for security or privacy on your mobile device, but it actually deteriorates the battery. Some of you may have heard of the Apple battery gate issue, where you had an old iPhone 3, the new 12 had come out, you get an alert that you need to do a software upgrade, and it self-sabotaged your battery. You're back in the store buying a $1,200 smartphone, which is a major expense for people on a fixed income and certainly during the pandemic. So we make that a prohibited practice under the Fair Business Practices Act. Today in Title 16, there are protections for Georgians specific to computer hardware, but we don't have them for mobile devices, so that would cover this. Additionally, we're not going to require app developers to only use the App Store payment system as the exclusive mode of distributing and paying for an app. So this is a benefit for Georgia consumers. This only applies for Georgia consumers when you go to check out of the 2 leading app stores. And third is you can't kick out or cancel an app just because they offer a cheaper payment option to Georgia consumers. We think that'll happen. Again, you introduce choice and competition, consumers are going to win. So that's the language, Mr. Chairman. I really appreciate the opportunity to speak and certainly available for questions.
Questions for Mr. Thompson? Okay, we've got a couple folks that want to speak on this bill. I'm going to recognize my friend Bob Dallas. Why don't you come to the podium, Bob? And then we're going to call someone on the phone here.
Thank you, Chairman Albers and members of the committee. I'm Bob Dallas. I served as the director of the Georgia Governor's Office of Highway Safety from 2003 to 2011. 2010 was the first iteration of dealing with the pandemic of using our smartphones while we drive. And many of you were here and recall that. Fast forward with the great work of this committee and Chairman Carson, we've got the Hansberry Law in Georgia. And setting an exact fine for the first offense as opposed to up to is very important to give to the public the conclusion that this is a serious thing. Secondly, getting rid of the free, get out of jail free card by what Representative Carson said is key to ensuring that the public understands they can't play that game. And with that, we believe we'll get more compliance. Let me just address, if I may, Chairman Harper's proposal. When that was discussed before, and it's been discussed quite a bit, why can't we use our phones when we're stopped at a traffic light, an intersection? Just remember, this is a very active scene. This is, you have pedestrians, you have cars that are obviously going into it, and then when the light goes from red to green, now it's your turn to move forward, the delay. And from GDOT's perspective, as well as the enforcement perspective, you're creating a lot of delay that will affect the efficiency of that intersection. But if you're like me, and we've all done this, right? The light turns green, somebody taps the horn because we didn't pay attention, and then you speed up. And so you're getting this kind of accordion effect, which does not help safety. And I'll conclude with this. With respect to enforcement, One of the things that Chairman Carson has been working on for many years is the idea that these laws are easier to enforce, because it's a difficult thing to see somebody using the phone or not using the phone and know whether or not they're violating the law. So that's one of the concerns I would have. So I just say, Mr. Chairman, I support obviously all the work that you all have done, and Chairman Carson in putting this together, because it will save lives.
Thank you, Bob. Appreciate your time today. Okay, we're going to put somebody on the phone here. Mr. Hayes, can you hear us?
I can, thank you, sir.
Great. This is John Albers. You've got the Senate Public Safety Committee, and this is our Cherokee County Solicitor General who wants to speak briefly on the bill. I'm going to put the microphone up to the speaker. Go ahead.
Well, thank you so much, Chairman Albers, for giving me the opportunity to speak on HB 247. I provided the committee with a letter of support already that outlines the first major reason that I support the bill that Representative Carson has brought, and that is to close that loophole that he's already gone through a good explanation of as to why that needs to be closed, and we certainly support that. Specifically, though, I want to take a look at lines 136 and 137 of the proposed substitute. And as you consider that, I'd like to call your attention to a 2015 study by researchers out of the University of Utah that suggests that after a distracting device is put down by the person operating the vehicle and the device at the same time, there is between a 17 and a 27-second continued realm of distraction that they call the technology hangover that persists after you stop using the distracting device. So including that language in subsection 5 in lines 136 and 137, the suggestion out of the University of Utah in their 2015 study would be that we are reintroducing a level of danger because of that technology hangover. And in the study, if you go back and look for yourself, the safest hands-free device that they were able to identify was still what they classified as a moderate level of danger. And the most unsafe in 2015 was what they called a highly challenging level of danger that was reimposed. So I certainly support 247. I think I can say very safely that the Solicitors General Association of the state is on the same page in supporting the bill, but we would urge great caution because of the studies and the research that does not necessarily support the idea that it's okay to interact with your device, even at a complete stop, because of the continued distraction that continues once you've finished that interaction. So thank you very much again for the opportunity to be here by phone and to interact with you in this way.
Well, thank you, and thank you for your service. You have a wonderful afternoon.
Take care.
Okay, that is everyone that we have signed up to speak on the bill. Is there anyone else here who wants to speak for or against House Bill 247? Please come on down to the podium, and if you could introduce yourself.
Senator, committee members, thank you so much.
If you just wait till you get to the podium, just so we can get you on the record, if that's okay.
I am Alan Poole. I'm the current director of the Governor's Office of Highway Safety. Bob still look a little bit better than I do, but let me just
Objection.
say,
We think you look much better.
well, thank you, Mr. Chairman. The way the bill is crafted today, committee members, it would close some loopholes that's in the bill. If the amendment goes forward, this will open up Pandora's box to give a litany of reasons why, if you're stopped, you could get out of a citation or whatever. Just food for thought. The way the bill is also crafted, it would give the Governor's Office of Highway Safety an opportunity to apply for $1.3 million of funding so that we can continue to educate the state and the drivers how important it is not to hold on or touch this phone while you're in a moving vehicle. Thanks again.
Thank you for your testimony. I know we've got other letters in our folders from our friends with the Sheriff's Department, Chiefs of Police. Would you like to speak to? Come on down to the podium, please, and when you're there, please introduce yourself, tell us who you are and who you represent.
Hi, my name is Pamela Bettis, and I'm the Solicitor General for Henry County. And I just wanted to talk with Chairman Harper about lines 136 and 137.
If you could speak into the microphone just so the people online can hear you.
That one of your concerns was that if you were utilizing, Google Maps or your GPS, that you might want to change your route, which is a very common thing that drivers need to do, particularly if they're on the interstate in Henry County. So I wanted to let you know that I believe, and it would be my opinion as a prosecutor, that line 72 through 80, 78 and 79. So line 72 through 79, I believe, covers that concern that you have, because at the end of line 75, it says shall not apply. And then in line 78 and B, the use of such device for navigation of such vehicle or global positioning system. So line 72 starts with, you cannot write, send, or read any text-based communication. And I believe, as a prosecutor, I would interpret that if the person is charged with changing an address in Google that they were writing, but this law would not apply to them because they were using the device for navigation purposes. So I think that was one of your concerns. And I think the other thing I would just state is that south of Twiggs and above Valdosta, they don't have any traffic lights down there anyway, so that part wouldn't really apply. So
We do have stop
signs. But I would just say it is dangerous for more metro counties, because the delay at the stoplight or the stop sign could then have the person charged with impeding the flow of traffic. And so you get into some confusion with application of the statute. Thank you.
Thank you for your testimony. All right, Mr. Butch Ayers with the Georgia Chiefs of Police. Come on down. I'm going to ask everybody to speed it up if we could, because we are going to get kicked out of the room and run out of time.
All right, thank you very much. I'm Butch Ayers. I'm the Executive Director of the Georgia Association of Chiefs of Police. I appreciate the opportunity to speak today. We're in full support of Chairman Carson's bill, House Bill 247. And I echo what all the previous speakers have said about traffic congestion, et cetera. But I want to add one additional thing that I don't think a lot of people have looked at. When you're at a stoplight or you're driving or anywhere and you're looking at this little screen right here, it's small enough that your entire attention is focused on that. And if you're focused down here, you're not focused around you. And I'll just say what I teach my daughters to do is to be observant when you are at a traffic light or stop sign, looking for the truck behind you that isn't stopping, looking through your rearview mirror. You're looking at approaching traffic that may have missed the curve and is heading into your lane, or you're looking at potentially the assailant or criminal walking up to your car, and you will definitely not see that if you're focused on your phone. But that's just the other end. I don't think has been really talked about, but I certainly appreciate the opportunity. Thank you.
Thank you very much. Okay, we have taken quite a bit of testimony. We've heard from most everybody who has signed up here. So at this point, I think we're going to turn it back to the bill's author for a closing statement, and then we're going to see what the will of the committee is.
Thank you, Chairman Albers. I just wanted to ask the committee, just think, saving lives. That's what I'm all about in regard to this legislation. I did have a question for Jenna in regard to, I just want to make sure that Section 1 of the bill would survive germaneness test in regard to public safety, in regard to Title 40. But I don't have any problem per se with people, doing, touching their phones and so forth, because that is part of the law. That is possible to do. I just have a concern for public safety if you're doing that and distracted from emergency vehicles, pedestrians, other traffic, and so forth on the roads.
Well said. Thank you. Okay, what is the will of the committee? Senator Jackson, you are recognized.
I don't know if this is in order, but I'm curious if Senator Harper is willing to withdraw his amendment.
Well, it's not an amendment.
No, it is actually part of the committee substitute. You can offer an amendment, but it is a committee substitute.
I'm going to offer an amendment.
Okay, and what would your amendment
At great
be?
risk that my friend from Blueberry Country might be offended. But I'd offer an amendment that we strike lines 136 and 137.
Okay.
And I think we'd have to also strike the or on line 135.
That would be correct. All right, so Senator Jackson has an amendment to beginning on line 35 with the last word of or and striking all of lines 36 and 37. Is there a second to her amendment? There's a second to her amendment from Senator C. Is there any further discussion on the amendment? Seeing none, if you're in favor of the amendment, please raise your hand. All right, and if you are opposed to the amendment, please raise your hand. Okay, that amendment fails. We are back to the original bill now, LC 393062 ERS. What is the will of the committee? Motion to pass from Senator Payne. Do I have a second? Second. Second from Senator Carter Summers. Is there any further discussion? Seeing none, all those in favor, please say aye. Aye. All opposed, please say no. I think very similar to the last vote. Okay, thank you very much. And who's carrying this bill for you in the Senate?
Well, I had asked Senator Robertson, but now I don't know. So, to be honest with you.
Why don't you get back to me before the end of the day, please?
Yeah.
That'd be great. Great, thank you. Okay, we are going to go to House Bill 579. Representative Oliver, you have been more than patient. I would say this is a pretty straightforward and easy bill. Don't talk us out of it.
Thank you, Mr. Chair. 579 makes an amendment to a general bill of Georgia law relating to public safety and judicial authorities that came out of the DeKalb leadership in the early 2000s. In around 2007, there was a successful attempt to apply a referendum obligation on an authority offering of bonds. CEO Michael Thurman and the DeKalb folks, that only county that's used this authority option now requests that the amendment be deleted. I believe we're in agreement that it was an anomaly back in 2007. Water authorities, housing authorities don't have referendums. Ask for your favorable consideration of removing the referendum.
I agree. Thank you. I talked to CEO Thurman as well. I think he's doing a great job there in DeKalb County.